I'll turn to the last case on this morning's docket. That is case number 104651, State of Kansas v. Sean Aaron Key.
May it please the court, the appellant and petitioner appears on behalf by Michael S. Holland II, Holland & Holland. The issue before the court started off being relatively straightforward but became a little bit more confusing after the Court of Appeals decision, so I will attempt to address both of the two issues. Before I do that, if I can please reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. The issue before the district court started off as being, does a criminal defendant have a right to challenge the validity, the constitutional validity of a prior conviction being used by the state to enhance the severity level of the crime for which he's charged? As the court is well aware, as in a DUI case, the state can use 2 or more prior convictions to enhance the severity level of the crime to that of a felony. The question is what procedure, if any, avails itself of a criminal defendant to challenge that? Mr. Key attempted at every possible stage of the proceedings to challenge the constitutional validity of the conviction.
With the possible exception of his plea.
Right.
And there's some lack of clarity in the record about what that plea was. Was it no contest or guilty?
I believe it was a guilty plea.
Okay.
But
I think it's checked no contest on at least one form, and so we were a little confused about that.
And Mr. Key did that comfortably with my advice because, and I guess if we're going to jump a little bit ahead to the Court of Appeals.
I know you filed a motion to dismiss.
Right. We at the preliminary hearing stage, which is what's so important, and I actually was the attorney on the Seams case, which was relied upon, ironically, by the Court of Appeals to dismiss this case on appeal. What Seams made clear was at the prelim, one of the fundamental statutory requirements was that the court determined that a felony has been committed. So the issue in front of the district magistrate judge at a prelim is there a felony? Well, in order to establish a felony, you have to establish 2 prior convictions. However, a district magistrate judge never gets into the constitutional validity of those convictions. So I attached in the appendix to the petition for review, showing specifically we allowed them to admit the documents, but we preserved the right to challenge whether or not they were constitutionally valid.
Right. You stipulated to admission only, not to validity.
Exactly. In order to avoid any possible waiver that we were not going to challenge those at a later date.
Right.
If Mr. Key had gone on to trial, been found guilty by a jury would not have been allowed to consider a single iota of evidence about the validity of those prior convictions or whether or not they even existed. Right. When he pled guilty, he only pled guilty to the elements of the crime. It has nothing to do with, nor are any of the elements of the crime, whether or not any constitutionally valid prior convictions existed. So there was no hearing on that. There was no fundamental right to object to that. There wasn't even an element or an argument that could be raised. And all of the courts beforehand, in Seams in particular, indicating that the only time you raise that is at the prelim, and then again at sentencing. Masterson and Larson, which both say, in different areas but also DUI law, saying the key to the charging document is if the state wants to convict you of a second-time DUI or third-time DUI or fourth-time DUI, you've got to charge out the maximum that you want to convict somebody of. And then later on, at the time of sentencing, you can argue about the validity of the convictions and whether or not it really is a first, second, third, fourth. But you got to charge it all. That sets your glass ceiling as far as you want to go. So the glass ceiling was set here at a level 3, but everybody knew all the way through we were going to argue about the constitutional validity of how they got to number.
The record's clear that you raised it repeatedly and by several mechanisms. What did you want to happen? Once you got to sentencing, once you've gotten that far, if it hasn't been taken care of prior to plea or trial, which it wasn't here, whether that was correct or not, we're going to fight over later. But what happens at sentencing? What are you seeking then? I saw what you were seeking in your motion to dismiss.
Right.
You wanted them to have to amend, basically, to dismiss the felony and order the state to amend to misdemeanor.
If we skip past what our arguments would be, yes, that's what we wanted. We
that's
wanted
what you
him
asked
convicted
for.
Of a second-time DUI, not a third, which would be a misdemeanor, not a felony.
Right. You were trying to force the state to amend its charging document. But once all that water has gone under the bridge after plea and you're there at sentencing, then what do you get? What is your remedy at that point?
Well, under Masterson and Larson, since the severity level for a DUI is determined at the time of sentencing, the judge can find him guilty instead or amend the conviction to a second-time DUI, not a third.
Okay. So in other words, you would actually be able to obtain vacation of the felony conviction in this case? That's what I'm asking. Is your conviction standing?
Technically, it wouldn't be, because that's what's so weird about DUIs. You don't get convicted of a felony DUI or a second-time DUI or a first-time DUI. There is no factual or legal determination made at the time of conviction. That determination
That it's not an element.
severity level is only at the time of sentencing.
Right, but that's what I'm trying to get at. What does the district court have the power to do if we wait till sentencing to fix this? And that's what happened here, is that everybody ended up, it all came to a head at sentencing. What does the district court have the power to do at that point?
Well, according to Masterson and Larson, and even seems to say that that's the time to take that up. Is at the time of sentencing.
I'm not disputing. I'm just asking, what do you get?
I think because of this weird system, I think everybody's getting caught up on it. It was a felony conviction. It never was a felony conviction. It was a DUI conviction yet to be determined as to severity level.
Okay, I see what you're saying.
So
how do we pass a Apprendi challenge? If the jury only determines the guilt of DUI, Apprendi talks. You've said Masterson and Larson about the elements, but Apprendi and its progeny has said, I don't care if you call it a sentencing enhancement or whatever, they're all the functional equivalent of an element. And you cannot sentence someone for any more than the elements found by the jury. In your case, the elements found by the jury would only be the first offense DUI.
And Your Honor, I haven't gone back and re-researched that, but I know when Apprendi first came out, that issue was argued, and they found that prior convictions, since they have different constitutional requirements, as long as they're constitutionally valid, can be used either as criminal history or to enhance the severity level of the crime. I'm not, as a lawyer who practices in criminal defense law all the time, I'm not in love with the process. I think it should be allowed to either be taken up at the time of prelim or taken up at least on a motion to dismiss. However, most district court judges across the state, based upon SEAMS, which specifically says this is to be determined at the time of sentencing, wait until the time of sentencing to do it.
Does SEAMS really say that it has to be then and only then, or does it say it has to be done by then?
Well, in SEAMS, I actually think is just spot on correct, based upon the way the statute's written and the way the law is, because the magistrate has to determine there's a felony, so you have to at least introduce the priors at prelim, so that makes sense. You don't want to introduce priors at trial, because then you're going to inherently prejudice the defendant, and that they're not elements of the crime in the statute, they're only sentencing elements. It would have been easier maybe to leave them as a criminal history element and not a severity level element, but I didn't write the statute. So there really isn't any other mechanism to do it other than allowing me to do it by a motion to dismiss before trial, which I tried, and the court said they didn't have jurisdiction
Isn't
to do it.
that really the best time?
In my opinion, yes. Procedurally, it makes most sense because it also avoids then having to have a 12-person jury, and it also puts both the state and the defendant in a position where they can probably negotiate and resolve the case anyway, if you can take care of it before you get to the trial stage, which makes sense. But common sense doesn't always get in the way of statutes or law, so I do what I can.
Well, there's nothing prohibiting that.
No, there's nothing
Is there?
prohibiting that. And other judges in other jurisdictions have allowed me to do that. And most of the time, the prosecutors are friendly to that.
Let me return to something about that, on the idea of a motion to dismiss hearing of some sort prior to trial or plea. Obviously, at that point, the defendant could come forward with actual evidence, put somebody on to talk about what happened. He could testify, he or she could testify as to whether this earlier plea was authorized, etc. Lawyer could be brought in, tell their side of the story. It seems to me that that's the most efficient time to do it. But the judge thought he didn't have jurisdiction. And you would agree that the judge didn't have jurisdiction to actually do anything to that prior misdemeanor conviction, correct? Isn't that where
Correct.
There's some confusion here?
That's
Because you're not asking for that. You never sought that.
No.
That's on the books. It's there. Will continue to cause him problems for the rest of his life, potentially. You're not attacking that conviction.
Not asking for it to be vacated.
Only as a sentencing factor in this case.
And only based upon the line of cases. They're pretty well established now in Kansas that say if there's a fundamental constitutional error, and it's always been, were you represented by counsel or did you validly waive counsel?
Uncounseled and subject matter jurisdiction.
And it's well established and well followed by all the district court judges that if that is the problem you're raising at the time of sentencing, then even if it's a sentence or a prior conviction being used to enhance, you can challenge that at the time of sentencing. If there was no attorney and no written waiver, that's gone. The severity level drops back down. You got a misdemeanor DUI. Pretty simple.
Okay.
Here, we have a very unique set of circumstances, which probably is never going to come up again, where somebody actually claims, hey, I didn't enter a guilty plea. My attorney did it for me. I never signed the journal entry, and there's not a record of it. And let me get up and testify, and I'll tell you what happened. We just didn't get to that point. I think I've addressed both issues kind of in a circular motion. If there aren't any other questions, I think that basically addresses all of the arguments at this time.
Any further questions of counsel? Thank you, counsel.
Thank you.
The state appears by Assistant Solicitor General Natalie Chalmers. The problem in this case is this court has to have jurisdiction to hear the appeal. The only argument the defendant has made as to why this court has jurisdiction that the state is aware of is under KSA 223602F, which applies to presumptive gridline sentences or KSGA sentences. DUIs are not KSGA sentences. So the defendant has not yet provided a statutory basis that this court has jurisdiction over this appeal. If there are no further questions, the state would...
It seems to me if one of the priors was uncounseled and improper, then can the defendant challenge the preliminary hearing determination of probable cause? Because then that would have been erroneous. The magistrate's determination that there was probable cause that a felony had been committed was erroneous because the evidence would not have supported that.
Are you asking if they could challenge it below or if they could challenge it on appeal?
If they're going to challenge it on appeal.
The only way...
I mean, that's really what has happened as far as the severity level goes. Forget about what the sentence is. But whether it's a felony or not requires that there be two priors.
Correct.
And that we've said it has to be presented at preliminary. And if the evidence at preliminary wasn't sufficient because one of the convictions was unconstitutionally obtained, then really what we have is a failure at the preliminary, don't we? A failure of probable cause?
Yeah, and if he'd gone through a jury trial after that, he absolutely could have challenged it. The problem here is you're limited under the plea statute because he entered a guilty plea or no contest plea in this case. Could he eventually get to that? I think yes. Do I want to make the defendant's argument for him on why he can get to that? Not particularly.
Do we have any further questions of counsel? Any further presentations?
No, thank you.
Thank you, counsel.
I will just very
Counsel,
briefly.
I don't see that you reserved any rebuttal time. Am I mistaken?
Yeah.
At 5 minutes? I'm sorry.
And
Please
I'll
proceed.
be much briefer than that, I hope. Essentially, the same argument being made by the state now is the argument made by the Court of Appeals, that this is more of a direct appeal and less of an appeal challenging the validity of criminal history and hence the validity of the severity level being more of a sentencing issue. This is a sentencing and criminal history issue. The only way you get to this being just an outright direct appeal is if they find, or if this court finds, that there was a waiver of those arguments by entering a guilty plea. There can't be a waiver of the severity level or the validity of prior convictions if they're not elements of the crime, and they couldn't have even been determined as a factual or legal basis at the time of either trial or plea. It just didn't make any legal or common sense.
And your argument is if it's not a criminal history matter, then it's an Apprendi violation.
Absolutely.
Any further questions? Any further presentation? Thank you, counsel. Thank you both for your arguments this morning. The court will take this matter under advisement. That concludes this morning's docket. Court is in recess until 9 o'clock tomorrow morning.